My name is Cindy Murphy. I'm a patent attorney in Cleveland, Ohio, and I'm here to talk to you about the new patent law, the American Invents Act, also known as the Lilly-Smith America Invents Act. Now, the new patent law has gotten a lot of bad press, and all you really hear about it a lot of times is we are no longer a first to invent. It's the death of the first to invent patent system. And in its place is first to file. And that is true to some degree, but it's not the whole picture, as we're going to get into a little further into the presentation. And also, there's a lot of sections in the American Invents Act that are specifically written to help entrepreneurs and small businesses. As a matter of fact, there's a Section 30 in the Act where Congress is going to specifically say that its intent is to develop new technologies, promote industries, spur growth, and create jobs, and most importantly for this audience, protect the rights of small businesses and inventors from the predatory behavior that could result in cutting off innovation. Congress realizes that the innovation is coming from startups and entrepreneurs, and it's very important that the patent law protect them. There's certain sections in the American Invent Act that are specifically written for entrepreneurs, not large business, not medium-sized business, entrepreneurs. One of them is the Ombudsman Program, Section 28, and what this is a special office, a department in the patent office where that does nothing but helps inventors, entrepreneurs, and small businesses work with the patent office to get their patent applications patented. This is leveling the playing field with the large corporations who have a team of in-house lawyers doing this for them. So that is, this department's full-time job is to work with people in the Ombudsman Program. There's also a pro bono program where the American Invent Act specifically tells everyone that is a patent attorney that you need to really be active and help in the pro bono program. And there's actually several of those that are springing up in Northeast Ohio that's covered in another video. There's also Section 10, which is called a micro-entity status. Before the American Invents Act, you had a large entity status which paid full fees, and that covered your large corporations. And you had small business, which covered businesses with 50 or less employees, and what they got was half of the large entity fees. So it cut a break for the small businesses. What happened, though, is your independent inventors and your entrepreneurs could only do as well as the small entity. What Section 10 of the American Act does is introduces a micro-entity status where you get 75% reduction off of the regular fees when you're filing your patent applications. This can make a significant difference in the amount of money that an entrepreneur or an independent inventor needs to set forth to file patent applications. There's also sections in the American Invents Act that were written for everyone, large businesses, medium-sized business, small businesses, but they're also particularly helpful to entrepreneurs and independent inventors. The first one of those we need to look at is the amazing race, and that's what I call the first to file. Now, before the American Invents Act, if the red inventor invented an invention, and the blue inventor later invented the same invention, what would happen is the red inventor was still entitled to the patent. Under the new law, now, if the red inventor invents the invention first, the blue inventor later invents the same invention, and if the blue inventor files first, the blue inventor is awarded the patent. So that's the difference between the first to invent and the first to file. However, there is something called amazing grace, first to disclose. And under this section, what happens is if your red inventor is the first to publicly disclose an invention, and your red inventor files a U.S. patent application within 1 year of this disclosure, even if the blue inventor filed before the red inventor is still entitled to the U.S. patent. So while it's true we've gotten rid of the first to invent, and that was the old law and no longer the new law, The American Invents Act is really a first to file or first to disclose patent system, and that's particularly valuable for your independent inventors and your entrepreneurs. Another advantage that the American Invent Act has for entrepreneurs and independent inventors is what I call trade secret triumph. A trade secret is a process that you keep secret from the outside world, and you use it to make a product that you go out and sell in the world. Trade secrets used to be used a lot by large corporations. They can't anymore because of employee turnover. It's very, very difficult to protect trade secrets in large corporations. In contrast, your independent inventors and your entrepreneurs and your really small businesses can really take advantage of trade secrets because it's a very closely contained system. The first thing in the American Invent Act that helps trade secrets is what I call bye-bye best mode. Before the American Invents Act, if you wanted to file a patent application covering a light bulb that you're selling, you had to disclose the best way of making the light bulb in the patent application. If you didn't, someone could invalidate your patent, in other words, take your patent away from you after it issued because you didn't disclose the best mode. Under the American Invents Act, a patent can no longer be invalidated based on the failure to disclose the best mode. So what happens is you have the advantage of filing a patent application that covers the light bulb that you're selling out in the stores, and you can keep the best way of making that light bulb a trade secret. Another section of the American Invent Act that helps trade secrets is Section 5, which is called the prior use defense. Before, if the red inventor was using an invention as a trade secret, and a blue inventor later invented the same invention, the blue inventor filed a patent application, the blue inventor would get the U.S. patent, and he could use that patent to stop the red inventor from practicing his trade secret any further. Under the new law, after the American Invents, if you have the same situation where the red inventor keeps his invention as a trade secret, the blue inventor later invents the same inventor, the blue inventor files his U.S. patent application, the blue inventor will once again get his U.S. patent. However, he cannot use that patent to stop the red inventor from practicing his invention. The red inventor has the advantage of being able to continue on with their trade secret. So you don't have to worry anymore if you're protecting something as a trade secret that somebody's going to patent it and then you're going to have to stop using your trade secret. Another thing that the American Invents Act does is Section 16, and this is called virtual marking. If you've ever gone to the store, just pick up anything in the drugstore and you'll see U.S. patent number, U.S. patent pending, notices on there. And the reason you do those notices is to put people on guard that there's a patent that covers this. Now, what you have to do is if it's a molded product or packaging or something, you have to print this notice on there. What virtual marking does is it allows you to put down the status of something and then refer people to a website where they can go and they can list, you have a list of the patents and the status of this. The advantage of this is you don't have to redo your marking, your packaging, your molds every time your patent status changes. So when you go from a patent pending status to a patented, or you add patents to your portfolio that cover your product, all you have to do is update your website. Another thing that the American Invent Act does is under Section 23, and they're establishing satellite offices. Before the American Invents Act, you had one patent office, and it was in Washington, D.C., Alexandria, Virginia, to be exact. Under the American Invents Act, satellite offices are being established throughout the country. There's one right now in Detroit, Michigan, which means that if you're an inventor in Ohio, you can drive to Michigan instead of Virginia to talk to somebody about your patent application. So all in all, the American Invents Act is very favorable to entrepreneurs and independent inventors. Thank you.